Constitutional conventions. Constitutional conventions defined. A convention is an uncodified rule of a constitution considered binding on political actors but not enforceable by courts. The constitution of a country is comprised of both written or codified rules enforced by courts and unwritten rules or principles necessary for constitutional government. While conventions are more binding upon political actors than mere usages, it is not true that they are less binding than constitutional law. There is no particular hierarchy of types of constitutional rules. In many cases, constitutional conventions are more important than written constitutional provisions. What separates a convention from constitutional law is that the former is not judicially enforceable. Courts may recognize the existence of a convention and even help define its nature and scope, but they do not provide remedies for the breach of conventions. Constitutional conventions differ from formal constitutional amendments in that they are created over time, and it may be difficult or impossible to identify when a constitutional convention has come into effect, or sometimes even what the constitutional conventions are. According to Jennings, the short explanation of constitutional conventions is that they provide the flesh which clothes the dry bones of law. They make the legal constitution work. They keep in touch with the growth of ideas. A.B. Dicey has defined conventions as conventions, understandings, habits, or practices, which, though they may regulate the conduct of several members of the sovereign power, are in reality laws at all, since they are not enforced by the courts. Marshall and Modi have defined conventions as rules of constitutional behavior, which are considered to be binding by and upon those who operate the constitution, but which are not enforced by the courts, nor by the presiding officers in the Houses of Parliament. A constitutional convention is a non-legal rule which imposes an obligation on those bound by the convention, breach or violation of which will give rise to legitimate criticism. And that criticism will generally take the form of accusation of unconstitutional conduct. The Queen will appoint as Prime Minister the leader of the political party with the majority of seats in the House of Commons, and ministers must be members of either House of the Parliament or the examples of constitutional conventions. Unenforceability of the conventions. Constitutional conventions are not obligatory, but are in effect procedural agreements which all sides adhere to. Some conventions evolved or changed over time. For example, before 1918, the British cabinet requested a parliamentary dissolution from the monarch, with the Prime Minister conveying the request. Since 1918, Prime Ministers on their own initiative request dissolutions and need not consult members of the cabinet. However, conventions are rarely ever broken. Unless there is general agreement on the breach, the person who breaches a convention is often heavily criticized, on occasions leading to a loss of respect or popular support. It is often said that conventions are not worth the paper they are not written on. They're unenforceable in law because they are not written down. Whatever enforceability they have comes from history, tradition, symbolism, and their cross-party support. The reason for obeying constitutional conventions. Conventions are obeyed because of the potential political difficulties which would arise if a firmly established convention were departed from without constitutional justification. For example, if the Queen appointed as Prime Minister someone who did not enjoy confidence of the majority of the House of Commons, he and his colleagues would be defeated in the lower house. As a matter of fact, the statesmen probably observed the conventions because they wished the machinery of the government to go on, and because they hoped to retain the favor of the electorate. The source of conventions. A conventional rule may be said to exist when a firmly established practice has been consciously adopted and recognized by those who operate the Constitution. A practice will be seen to have become at the point at which failure to act in accordance with it gives rise to legitimate criticism. According to Jennings, if the authority itself and those connected with it believe that they ought to behave in a certain way, then the Constitution does exist. Practice alone is not enough. He also adds that there must be a reason for the rule. The creation of a convention must be due to a reason of the thing because it is consistent with the prevailing political philosophy. Constitutional conventions generally arise from precedent. For example, the Constitutional Convention that the Prime Minister of the United Kingdom must govern with a majority in Parliament derived from the very unsuccessful attempt of Robert Peel to govern without one in the mid-19th century. The effect of breaching constitutional conventions. Being non-legal rule, there is no question of breach of convention being enforced by the courts. The courts do not have the jurisdiction to enforce the conventional rules, although they may give recognition to them. However, it is also the case, as Dicey argued, that breach of a convention may lead to a breach of law. The most often cited example offered is that if Parliament, in breach of a convention, did not meet annually, the consequence would be that money granted on an annual basis by the Parliament for the maintenance of the armed forces would not be forthcoming. Accordingly, maintenance of the army would become unlawful by virtue of Article 6 of the Bill of Rights 1689, which provides that raising or keeping an army in peacetime without Parliament's consent is unlawful. Such consequences are the exception. For most of the part, the consequence of violating a convention is political rather than legal. Classification and illustrations of the constitutional conventions. Constitutional conventions may be classified into four main categories: conventions relating to the exercise of the royal prerogative, and conventions relating to the working of the cabinet system, conventions regulating the relations between the Lords and the Commons and the proceedings in the Parliament, conventions relating to the relations between the UK and the Dominions, conventions relating to the exercise of the royal prerogative. The legal powers of the king are still passed. According to Dicey, conventions are rules for determining the mode in which the discretionary powers of the crown ought to be exercised. Constitutional monarchy and cabinet government depend entirely on these conventions. The following are some of the most important conventions which regulate the exercise of these prerogative powers. Number one, the king must invite the most influential leader of the party or group commanding a majority in the House of Commons to form a ministry. Number two, the king must appoint as his ministers such persons as the Prime Minister may advise him in the matter. Number three, the body of ministers so appointed becomes the government, and the inner ring is called the cabinet. Number four, the king is bound to exercise his legal powers in accordance with the advice tendered to him by his ministers through the Prime Minister. Number five, the king must assent to every bill passed by both the houses of Parliament or passed by the House of Commons in accordance with the provisions of Parliament Acts of 1911 and 1949. Number six, Parliament be summoned to meet at least once a year. Conventions relating to the cabinet system. Prima facie, the ministry is entitled to continue in the office as long as it enjoys the confidence of the majority party in the Commons. But if it is outvoted on a major issue, or if a vote of confidence is passed, then it is bound to resign. Number one, the ministry is collectively responsible to Parliament for the general conduct of the affair of the country. Number two, the cabinet should not advise the crown to declare war or to make peace or conclude a treaty unless there is sufficient ground for them to believe that Commons approve of such a measure. Conventions regulating the relations between the House of Lords and the House of Commons and the proceedings in Parliament. According to Dicey, the following conventions have grown up regulating the relations between the two houses. Number one, in case of a conflict between the two houses, the will of the House of Commons must prevail. Number two, peers who do not hold or have not held high judicial offices do not attend when the House of Lords is sitting as the highest court of appeal. Number three, proposals involving the expenditure of public money may only be introduced on behalf of the Crown by a minister in the House of Commons. Number four, the businesses of the House of Commons is rearranged informally, binding the Speaker's chair between the leader of the House and the leader of the opposition. Number five, political parties are represented on parliamentary committees in proportion to the number of their supporters of the House. Conventions regulating the relations between the United Kingdom and the independent members of the Commonwealth. These conventions provided for the method of cooperation between the members of the British Commonwealth inter se and regulated negotiations between them and foreign countries. Among the more important of these conventions are: number one, the Parliament of the UK may not legislate for a dominion except at its request and with its consent. Number two, any alteration in the law touching the succession to the throne of the royal style or titles requires the assent of the Parliament of the UK as well as the Parliament of Canada, Australia and New Zealand. Number three, in appointing the governing general of a dominion, the king acts on the advice of the Prime Minister of the country. Number four, the Governor General is the representative of the King and not of the British government, and acts on the advice of the Dominion government as its constitutional head. These conventions are merely matters of practice. No legal proceedings can be taken for the breach of a convention. No court can take direct cognizance of these constitutional understandings, yet they are as rigidly observed as though they were embodied in a statute. Thank you, viewers.